My name is Peter Gordon and I'm the Senior Partner of Gordon Legal. I ran the first asbestos-related cancer negligence claim in Australia. Started in 1984 and it went to trial in 1985. It was at a time where lawyers didn't try to bring negligence claims for asbestos-related cancer. People who got mesothelioma didn't live long enough for their trial process. Klaus Rabenalt was a man born in Germany, stopped over in Western Australia for about 6 months at Wittenham in the blue asbestos mine, owned and operated by CSR through its subsidiary company Australian Blue Asbestos. Some years down the track, I was to be leaked a confidential document saying even if they die like flies, they'll never be able to pin anything on CSR. He did his 6 months there, came to Melbourne, and he was in his early 50s when he felt a pain in his chest. Klaus presented a game-changing dynamic in the war against CSR. He had lived in Victoria for 30 years, and that gave us a fighting chance of keeping the case in Victoria. And we got the right to a jury. In other words, we got the right to a fair trial. Part of the job of properly preparing these claims was to actually see what the conditions in the mine and the mill were like. We flew to Wittenham. We drove the 7 kilometres out to the Colonial Gorge mine and mill to find that it had been chain locked. So it was fun to watch these erudite QCs breaking and entering into the mill. And we'd been there for 20-25 minutes when I chanced to just look up, and there was a hole in the ceiling and the sun was shining through it, but it wasn't gold, it was light blue. Klaus got on for trial 4.5 months after he first walked into my office in Nicholson Street, Footscray. The trial itself went for 6 weeks because the evidence was so clear that CSR knew that they were pronouncing death sentences to most of their workforce. We had a long argument about what steps we could take to make the effect of a win more emphatic. The method that we eventually agreed upon was to make an extra claim for punitive damages. In fact, it had at that point never been done before in Australia's legal history in an industrial negligence setting. The judge charged the jury, including as to punitive damages. The precinct of the court was really quite crowded and there was a rising sense of anxiety on both sides. I mean, the consequences for CSR of losing were financially and reputationally massive. After 4.5 hours, we got word that the jury had a question. We've decided that there was negligence on CSR's part and we've assessed the damages. We've also decided to award punitive damages, but we'd just like you to explain to us the principles by which we assess how much extra damages to give the plaintiff. At which the entire courtroom kind of erupted, and because it was clear that we'd won. We came out of the court just after night had fallen, and there were these bright lights everywhere and cameras and microphones. So I was like a rabbit in the headlights, but Klaus was really very calm and said, I just feel that we've come to justice now.
It's not the money, it's just the every wonder case.
When he died 10 or 12 weeks later, which is odd because you see him that night, there's TV footage of him on the 7:30 report that night and he looks healthy. He didn't live much longer. That's what mesothelioma is like. I look back on it and I feel really proud. It's a really important contribution to Australia's working people and to standards of safety. Over the 30 years that followed after that, I've been involved in a lot of important struggles, but looking back, none of them were more important.